wouldn't we do it anyway? For example, I'm a songwriter, but I've pretty much never made anything off of the songs I've written. I still write them, you know. So maybe it's not necessary. Maybe we don't have to have this complex federal and in some cases state system of laws to safeguard what we create. We probably do it anyway. What do you think? I mean, if you, yeah, go ahead.
Like, I mean, for my growth, one of the like the incentives for like research and development have to be there for businesses to pursue that stuff, I guess.
Okay, I didn't quite catch all that. You said incentives for research and development?
Yeah, right. If you don't have the IP, then it gets rid of this.
Why wouldn't people still invest in R&D for whatever it is, a new cure, a new medicine, if they couldn't legally protect it?
Because they'd probably get like more profits elsewhere.
Yeah. If you can't protect what you're inventing, well, some of these inventions cost a lot of money to come up with. As you say, research and development. I mean, it doesn't cost me anything to write a song. I just sit down and I do it, spend a little time, that's about it. But if you're talking about a new pharmaceutical, a new medical device, or some drug that might be a cure for some disease, it costs millions of dollars and years of time to research it, to test it, to come up with different formulas. And you'd be really stupid, frankly, to do that if you couldn't then profit from what you create. Unless you're strictly, you know, like a living saint and you just want to spend your riches to come up with inventions that you then, hey, have at it, folks. I created it, spent $15 million to develop this. Have at it. I don't have any legal claim to it. That would be a really rare person who would do that. You'd have to be either crazy or just a world-class philanthropist. Other ideas, other thoughts about it. Is it a case of supply and demand? Like if you protect creations, you're likely to get more of them, and if you don't protect them, you're likely to get less of them. You probably know some people who are in a garage band of some sort, who are whatever kind of music they play. They just play, and they get together occasionally. They maybe get a gig once in a while, but they don't really make much money, and maybe they don't make any at all. But by golly, they're still there practicing and recording and making their own videos. Why do they do it? I mean, don't they love what they do? Wouldn't they continue to do it even if they didn't have any legal claim to the songs or the videos or the dances that they create? Sure, if truth were told, some of you are creative. There's no one going to force you to divulge that secret, but I'll bet some of you write things for fun, whatever it might be. You clearly are doing that, even though right now you're not making any money off of it. Is it the prospect of maybe someday you will make money that keeps you doing it? Or if you knew that you would never make a dime from it, would you do it anyway? Maybe a little of both. Maybe some things we would do because we have a passion for it. We feel like we're meant to create certain things. Maybe we never make any money, but we make a few friends and family happy. We share what we create with a few people, and maybe they enjoy it, and that's payment enough for some of us. But the idea behind these forms of IP protection is, yeah, it might be enough in some cases and in some categories of what we create, but it's not enough in every category, and there are some useful inventions or creative works that we really want to encourage. We want to subsidize it in some way, at least by saying, look, you make it and you go through this process, then you can profit from it and keep anyone else from ripping it off, at least for a certain period of time. We'll create that protection for you to encourage you to do more of that. We want more useful inventions. We want more innovations that make life easier and better, make the world a healthier, safer place. And we'll protect what you create to ensure that you have every incentive to keep doing what you're doing. Because in some way, the people who make the laws, and indeed the people who wrote the U.S. Constitution, felt that people respond to incentives. Maybe not exclusively, but it usually helps if you know that you can make money from doing something. It usually helps if you know that you can get credit for something in the public sphere. That people would know, yeah, that guy, they invented that, or she created this software. And that means something to a lot of us. So there are reasons why these different forms of IP protection exist. And I'm going to just mention something that came up last week. We were talking about the sources of law and who has the right to issue or create or promulgate different types of law. And one thing we mentioned is at the federal level in this country, the lawmakers are the United States Congress. And I'm just going to randomly pick on one of you, give you an opportunity to excel. Maybe I'll ask you, sir. The U.S. Congress is composed of two groups of people. What are those two groups of people?
To be honest, I can tell you.
Oh, okay. How about you, sir? U.S. Congress, two groups of people together make up the Congress. I'm telling. I'm going to tell on you. Oh my. Okay, yes.
Senators, representatives.
Say that again.
Senators and representatives.
Senators and representatives, yes. The United States Senate and the United States House of Representatives. Two different groups of legislators, lawmakers at the federal level. And this is a little bit of review. Don't shoot from the hip on this, because some of you have a habit of thinking that you're right about something and you're not. Maybe I'll ask you in the back, sir. How many United States senators are there at any point in time? Yeah, U.S. senators.
100?
Yes, 100. Oh, I live again, yes. And why are there 100? There's a formula that is
Two each state.
2 in each state. We have 50 states. I'm no math major, but 2 times 50, I think it equals 100. That's how we get 100 senators. So that's a very exclusive club. Only 100 senators at the United States level. 2, and only 2 from each and every one of our 50 states. Yes. In that sense, all states are equal. Whether you have a few people or a whole bunch, you get 2 senators. In that sense, we want all the states to have an equal voice in our lawmaking process. On the other hand, as part of the system of checks and balances, the separation of powers that's baked into our government at various levels, on the other hand, it was thought that, yeah, in one sense, for the Senate, we want all the states to have an equal voice. It's only right. Fair is fair. On the other hand, when you have more people, like today, California or Florida or Texas, shouldn't that number of people mean something at the federal lawmaking level? Yeah, there's an argument to be made. Sure, you have more people, they should have a louder voice than little tiny band of people who live in Alaska or Wyoming. And so for the U.S. House of Representatives, the states don't all get an equal number. The number increases as the state's population increases. So currently, and by statute now, there are 435 members of the House of Representatives. And some states have way more than others. Like California, I think, has 54. Many states have only 3, at least populous ones. So those two groups of people get together, and together they are the U.S. Congress. And they have powers under the Constitution to make laws, to legislate in certain categories of human activity. They don't just have blanket power to write any law they darn well feel like it. They might think they did too, but the Constitution is basically the people's license. We're giving permission to certain groups of people in the government that we form to make laws. It's not a blank check. In Article 1 of the Constitution, Section 8 of Article 1 of the Constitution, they list out 18 different categories of lawmaking. And one of those, they single out to write laws for the protection of useful inventions. This is the source of the authority in the Constitution for the Congress to write laws at the federal level for copyright, for patents, and for trademark, and to a limited extent for trade secrets. That's where the law authority comes from. If it weren't there, Congress wouldn't have the power to make any such law. But there it is. Questions about this so far? Now we're going to do a little bit of a dive into each of the categories of federal IP protection. And this may be a little bit painful. I'm sorry for that. But trust me when I say it's a lot more detailed than I'm about to tell you. This is, after all, a very broad-based overview course in the legal environment of business. There are, at the law school level, entire semester-long courses in these laws. I'm going to give you the basics here. And that's what I'm expecting you to know, the basics. But to know the basics accurately, not approximately, not guessing at them, to know what each of these forms of IP protection does and does not do. And we'll start with what I've helpfully numbered as 1 on this list, copyright protection. Copyright is a form of legal protection administered by the U.S. Copyright Office. It is located in the Library of Congress, right there on Capitol Hill in D.C. Some of you have probably been to D.C. When you walk past the Library of Congress, you may or may not have known that's where the U.S. Copyright Office is. So what do? Copyrights are a legal protection that is applicable to certain types of creations. Just for fun. How many of you know just one type of human creation that is eligible for a copyright if you go through the right procedures? And I dare say this, every one of you, whether you know it or not, owns several copyrights. In fact, you probably own hundreds of them. You have your hand?
Like logos, or isn't branding?
No, that's a logo, a brand, not a copyrightable item. That's for trademark, like the Nike swoosh or the Golden Arches of McDonald's. Those are trademarks, not copyrights. Copyrights are for other kinds of creation. Yeah, songs. Songs are something that can be copyrighted. Now that you know that, what's another kind of human creation that could also be copyrighted, protected through copyright law?
Like an essay?
An essay, yeah. I'm sure you've all written hundreds of essays in your academic career. You didn't know it at the time probably, but just by writing an original paragraph or term paper or whatever you might call it on a particular topic, if you put any original work into that at all, that is a copyrightable article. It's a human creation that has some value in the eyes of Congress. So if songs and essays or articles can be copyrighted, what's another thing that could be? I'm sure some of you are artistic types, creative types. If you spend your idle hours creating beautiful works of, I'm not going to tell you because then that would be another category of copyrightable stuff. But what's another thing you might be able to copyright? How about you, sir? Can you think of something? Say that again. Artwork, yes, beautiful. It doesn't even have to be in words. It could be a painting, a drawing, something create with sculpture, that can be copyrighted. It's a work of art. Wow, this is so cool. There are many other things. Are there any poets among us? Don't worry, I'm not going to ask you to read one of your poems. But have you ever written a poem? Maybe for a Valentine or somebody you like, or for your mom. Poetry is subject to copyright protection. So are plays, whether it's a dramatic play like, I don't know, Streetcar Named Desire, or a musical play like Wicked. That can be copyrighted. Dramatic works. Performances, a particular way in which something is performed, can be copyrighted. All sorts of things. We could go on and on, but computer code, the computer code necessary for a video game, is subject to copyright protection. Choreography. If any of you are dancers or you fancy yourselves as a choreographer, you come up with a certain way of mapping out how the moves are going to go in response to a certain song, that is copyrightable. In all of these cases, and there's a whole bunch more, a novel, a nonfiction work. I'm an author of 8 books. They're all nonfiction, but they're all copyrighted. If you write something, whether it's fiction or nonfiction, a short story, a full-length novel, subject to copyright. In order to be copyrighted, though, it has to be in some way reduced to a tangible form, written down, put into electronic form, carved into marble or granite. It has to be reduced to some tangible form. And that goes sort of without saying. I mean, how can you copyright something if you can't say, well, here it is? But anytime you come up with anything, an essay, term paper, a poem, a song, and you either make a recording of it or you speak it into your phone or anything like that, you've now reduced it to a tangible form. You can share it with others, as I'm sure you do countless times every week. That is then eligible for copyright. And some of those things might be so trivial, you think, well, come on, why would I bother? Well, under copyright law, you actually own the copyright to anything that you create in those many, many categories, whether you register the copyright or not. But the Copyright Office in the Library of Congress exists as a place where you can send your creations with a little form. You can do it all online, and a nominal fee. This doesn't cost hardly anything, in stark contrast to, say, patents, which can cost tens of thousands of dollars. Copyright, if you want to register a copyright, only costs a few bucks. And then you get a little certificate that you can show off to people. Maybe it's with some bragging rights. But other than bragging rights and a little quiver of feeling of accomplishment, why might you want to register a copyright with the Copyright Office? So you can say, look, I wrote this script on this date, and here's what it is. I think it could be the start of a new Marvel Cinematic Universe franchise. I've created a whole new set of characters. It's going to be the new Avengers series. I've written this script, and I'm going to register this with the Library of Congress Copyright Office. Why might you want to register copyright for something you create? Let me know. If you create something like this new script, you think it could be the key to a whole new Marvel Cinematic Universe series of movies. You've written this script. Before you go showing it to anyone, you register it with the Library of Congress Copyright Office. Why might you want to do that?
So you don't get too far and it get copyrighted.
Yeah, you don't want to go showing it off to the people at Marvel and say, hey, isn't this cool? By golly, you're right, it is. Thanks. And they copyright it before you, and then you're in a difficult situation because you really did create it first. And if Marvel decides they're going to copyright it with a registration before you do, now you got a problem. I know I wrote it before them. I actually showed it to them. I gave them a copy. Yeah, but they didn't register it. Oh, yeah, but I trusted them. Well, too bad. Now you have to prove, if you want to bring an infringement case in court, you have to prove that you did it before they did, and they took your original script and stole it. Well, chances are they have really high-priced legal counsel at Marvel Incorporated, and now you're there as a private citizen, hard to scrape up enough money to hire a lawyer at all, and it's not going to be a whole team of high-priced counsel that Marvel has at their disposal. You're probably going to have a really hard time winning that case, even if you're in the right. That's why, before you go showing your creative work to anybody who might be in a position to copy it, take it, claim it for their own, it's a good idea to register it with the Copyright Office. It doesn't cost much. I've done it a bunch of times with my own work, and then you know, you've got a certificate that on this date, the Copyright Office received a copy of my work, and they issued me this certificate. So if anyone else later claims that they created it first, I can show, well, no, you didn't. Here's the proof. Powerful evidence that you are the creator and the copyright owner. So if you are a creative source, or you think you're going to go into business in the creative realm, whether it's TV or movies or music videos or what have you, it's a good idea to keep in mind, we're going to actually register everything that we come up with. We're not going to play a game of chance with this. We're going to make sure that we have proof that this was registered on a certain date. Questions so far? Okay. Now, how long does copyright protection last? If you ask a lawyer any question, almost guaranteed the first thing she or he is going to say is, it depends. And in this case, it does depend. For regular, not for hire, just we do it because we like doing it, those kinds of creative things, you write a song, a poem, a play, a screenplay, a novel, that protection lasts for, under current law, the life of the author, in this case, you or me, how long we live, whether that's a few years or a bunch of years from now, plus an additional 70 years. That's a good long time. That's how long most copyrights endure. The life of the author plus an additional 70 years. Can't be extended beyond that, but that's the length of protection. Once that expires, the work slips into what's called a public domain. And then anyone's eligible to take it, modify it, write a musical based on it, do a parody, and without paying any royalties to the original author. I'm sure at some point in your academic career you've read or pretended to have read The Great Gatsby by F. Scott Fitzgerald. That slipped into the public domain just a couple of years ago, and that's why you're seeing all these movies and indeed a musical on Broadway about The Great Gatsby, because now they don't have to pay F. Scott Fitzgerald's estate any money anymore. It's just free for all. So that's non-work for hire. People do it as an individual. But many of you are going to be employed by a company that creates things. You hire people because they're creative, and you pay them to write scripts or songs or ad slogans or jingles, whatever it might be. When you do that, that's a work for hire. You're paid to create. If you're a working stiff and you're on the payroll of Microsoft or Apple to write computer code, whatever code you write doesn't belong to you. You say, yeah, but you said computer code is copyrightable. Yeah, but if you're hired to do it by a company and you create it as part of your job, the company owns that and they will copyright it. And that kind of copyright doesn't last for the life of the author plus 70 years. The for hire copyright lasts for either 95 years from the date it was first published or 120 years from the date it was created. 95 years or 120 years, whichever is shorter. And that's just a different rule. It was thought by Congress when they wrote the copyright protection statute that it'll be a different rule when it's a work for hire. They didn't have to make it that way, but that is the rule. So companies then that are in the business of songs, software, whatever you might have, keep track of how long they still have remaining on their copyrights. And their competitors are also watching, because if something has enduring value, then when that copyright on a work for hire runs out at either the 95-year or the 120-year point, they're going to swoop in and say, okay, now we can take the ball and run with it. Maybe take it in a different direction, a whole new generation based on whatever it is, a Black Panther, Captain America, Batman. And there will be a lot of people licking their chops saying, oh, finally that copyright ran out. Now we can swoop in and take the ball and run with it in a different direction. Maybe open up whole new avenues of revenue that previously were unexplored. And by the way, that's one of the arguments that is often made against these legal protections. Because when you open up an idea to more people, saying, look, here's the basic idea. What do you think? Can you take it to the next level? Can you take this idea and build on it? Maybe make it even better, or able to function in an additional field where we didn't originally think it would work? The value can multiply. And it's true. And that's, I guess, the main reason why these protections expire at some point. They're in place, they're exclusive for the copyright or patent owner for a certain number of years to reward them, to incentivize them to get out there and create more things like this. But at some point the protection ends, so that then the other public policy good steps in. Now more people can take this and build upon it, create even more things for people to enjoy, to use, to profit from. Okay. By the way, copyrights cannot be extended. If you create a new, while you still own the copyright, you make a variation on the theme, like if F. Scott Fitzgerald had lived long enough to write Guess What, Gatsby Didn't Die. He came back and he had a whole nother series of adventures after he thought he was dead in that swimming pool. If you write a new work based on your original creation, well then that's a separate work. It's not going to extend the original copyright, but that new variation will itself be copyrightable for another life of the author plus 70 years. What happens if something is copyrighted and then somebody else infringes on it? And we say infringes, steps in without permission, without paying a royalty to the copyright owner, takes it and claims it for their own, or they perform it on stage or in a movie without paying for it. Any song that's copyrighted by somebody, you can't take it and record it or perform it live legally without permission, without paying a royalty. So if there's an infringement case, typically there's going to be a civil cause of action. You can sue the person or the company that infringed on your copyright. And if you prove your case and you're successful in court, or you settle out of court, you can get them to disgorge to you all the profits they made, reimburse you for the lost profits that you would have had but for what they did. And in cases of deliberate copyright infringement where they knew it was protected and they stole it from you anyway, you can get what's called treble, which means triple damages. Whatever you can prove it cost you, you get that times 3. Those are the remedies available in a copyright infringement lawsuit. And in some cases, there can be criminal prosecutions based on intentional copyright violation. It's taken that seriously. And the penalties for criminal copyright violation can include 5 years in prison or even longer, plus a monetary fine. That's a very quick and dirty summary of copyright law. Questions about that? Some of you may have heard about the so-called poor man's copyright. Because really the idea about copyright registration is you register your creative work with the Copyright Office. Now you have proof that on that date you had written this, reduced it to a permanent form, and sent a copy to the Library of Congress. For many decades, people would say, yeah, but you don't have to go through all of that, Mr. Goss. You can just put your creation in an envelope, mail it to yourself, you receive it, you don't open it, you just put it in a safe deposit box, you keep it forever. And then you have a sealed envelope with a postmark on it that says whatever date it was postmarked, and you can say, look, if it ever comes to a dispute, you can produce this envelope. We'll open it in court. We'll have the judge open it and read the contents. Oh, by golly, you're right. On that date, way back in 19 whatever, you had written this document. Yeah, it's sort of it's a way of proving that you had written the creative work on a certain date. But, it's not that expensive to register your copyright. So if you really think you've got something, a script, a playwright, a manuscript, a screenplay, go ahead and register it. It'd be cool anyway to be able to show your friends and family, here's my certificate with the Copyright Office. Enough said on that. I'll pass around our fancy rained upon attendance sheet. It's now the 27th of October. Go ahead and put your name on that. I appreciate it. All right, the second main category of copyright, not federal IP protections, is patent. Patent for both utility patents and design patents. Now this is covered by federal patent law, and there's a U.S. Patent and Trademark Office in Washington, D.C. that has a department devoted both to patents and to trademarks, part of the same huge organization. But they're under separate statutes. Patent, first of all, to be covered by a patent, it has to be a useful invention. It's really a 3-part test for whether something is able to be patented. It has to be new, not just a small variation on a pre-existing thing. It's something new, significantly new. It has to be useful. It has to be something that has a practical purpose. It does something. It functions in a way that we would find valuable. It has utility. It's useful. It has utility. And it has to not be obvious. You can't just be, well, anyone who's familiar with how you do this particular activity would have known, of course, you would go through this procedure and do it. So new or novel, useful, practical, and non-obvious. There are certain types of things that are not able to be patented, like naturally occurring living organisms. You can't patent them. You don't patent naturally occurring animals, plants. It's just not subject to patent law. But inventions, utility patent is basically what we think of as an invention. You come up with a new machine, a new device, a new process. A new measuring technique, any of these type of either products or activities can be patented. A new system for doing something, an algorithm, a formula can be patented if it indeed has practical value and it's new and it's not obvious. As we mentioned a little while ago, here in the utility patent world, some inventions don't cost that much. You come up with them just by messing around with what you've got in your garage or your workshop. And it takes you some time, some trial and error, but it's not that expensive. Other things are extremely costly. Huge amounts of R&D money goes into testing new prototypes for rocket ships, satellites, automobiles, cameras, cell phones, pharmaceuticals, etc. And so, it's big business if you're involved in that kind of enterprise to come up with utility patents for what you do create. Because a lot of what you are working on turns out to be a dead end. Looked good on paper, we thought it had promise, but it turns out not to work, or it doesn't work efficiently enough, or it's too cumbersome, people aren't going to buy it, people aren't going to use it. Or yeah, the pharmaceutical does work mostly, but it has some terrible side effects. It's just a dead end. We're going to skip the whole thing. So there's a lot of dead ends involved in the invention world, and so utility patents are a way of providing some guarantee for those who are successful eventually to say, okay, now we've got a winner. This one is going to pay for a lot of the dead ends, a lot of the failed attempts that falter along the way. You need an occasional big payday to pay for all those dead ends. No one sets out to fail. All of these had some promise and maybe spend years in R&D with various prototypes and testing involved, only to find out most of them just don't cut it. The ones that do, you're going to make sure that those utility patents are done perfectly. And there's a way on the website I sent to you via email. You can go and you can search for already registered patents in whatever category you're interested in to see, is there anything that's already protected that I might be infringing on without knowing it? One thing about patents is, once it's granted, you can find what's been protected. You can see, because they have to describe it. The patent owner, to get a patent, has to submit to the patent office sufficient description that they can understand how it's made, how it works. So you're giving up to the people in charge of issuing patents a lot of very valuable information. And maybe your potential competitors will see that and say, oh man, maybe we can take this and without infringing on the patent, come up with something that is just as good, but in a different way. That's a dangerous enterprise, but people try to do it all the time in utility patents. Now, how long does a utility patent last? Well, under current patent law, it's changed over time. Currently, a utility patent is good for 20 years. 20 years. And well, geez, if you invest many millions of dollars in an invention, is 20 years enough to be able to recoup all of that R&D cost and then make it profitable enough? Well, I mean, Congress has been known to be wrong. That's the number they've picked. And it really can't be extended, not for the original invention. Maybe you come up with a variation that takes it to the next level and that itself can be patented. But that original patent is good for 20 years and that's it. That's for a utility patent. If you infringe on a utility patent, typically there's no criminal prosecution likely unless it's like patent is gonna be a civil lawsuit. Somebody can sue you in federal court, or you can sue them in federal court saying, you infringed on my utility patent, and here's how. Here's what my patent said, here's what you came up with. You basically just copied my invention without permission. I had the exclusive right to use this during the 20 years my utility patent lasted. You didn't seek my permission. You didn't get a license from me. You basically stole my idea. And in the case of deliberate patent infringement, the remedy can be treble damages, once again. 3 times what the actual damage to the patent owner was. Multiply that times 3, and that's when you can successfully sue the infringer to pay you. There's another type of patent. In addition to utility, there's a design patent. Utility patents are all about how it works. How does it function? How does it do what it does? And that's all very valuable. But there's also value in, well, what does its look? What's its appearance? What does it feel? What vibe does it give off when you see this thing? What is there about it that makes it attractive to you, makes you want to use it? Design is important in the world of commerce. And so there's a separate category of patents called design patents. It involves, patterns for fabrics, a particular look for a cell phone, a way a car might have its lines, its contours, all sorts of things. That is all about look and feel and vibe, appearance. And still the same patent and trademark office in Washington, D.C. Design patents are only good for 15 years instead of 20. Congress came up with a number. Nothing magical about 15 years for design patents instead of 20 for utility, but that's what Congress came up with. The theory being, well, fashion, trends, what looks cool, what people will pay money for because of the appearance, that's always changing, so 15 years is plenty. I don't know, they may be right, they may be wrong, but the duration of a design patent is only 15 years instead of 20 for a utility patent. Questions about patent? I spent 7 summers in the People's Republic of China teaching university classes, and sad to say, China has often been accused of infringing on patents. And anecdotally, I can tell you, just looking in fancy malls in China, in big cities, I would see things that are obvious knockoffs of products that would be popular in the U.S., like Beats by Dr. Dre. You would see them in the mall, and it looks pretty good. I wouldn't probably be able to tell the difference, but my younger daughter could. She would be, Dad, that's fake. You could tell that this is wrong here. Fooled me. But, internationally, there's a lot of controversy over people ripping off patents, and usually we're the ones who are being ripped off. There's international law that governs this, and it's part of our uneasy relationship with nations like the People's Republic of China. And when we lose our patents, or as a cost of doing business in China, the Chinese government insists that we sign over our utility patents to them, just so we have access to the enormous 1.3 billion people Chinese market. That's a major cost. Businesses don't do that lightly. Sometimes they agree to it. Boy, that's a stiff price to pay. These intellectual properties are sometimes hard to quantify, especially in terms of their future value. But boy, if you happen to sign away the rights to something that turns out to be huge in the future, you'll be kicking yourself for the rest of your life. When Stephen Schwartz wrote Wicked back around the year You know, he obviously was riffing off of The Wizard of Oz. And there were a lot of legal negotiations between MGM Studios, the copyright owner of The Wizard of Oz film, and Stephen Schwartz and the company that was working on the Wicked musical on Broadway. But they realized, you know, Wizard of Oz, it's sort of creepy in its way. You can say, well, then it's got some appeal, it's got some enduring value, but some things people find politically offensive these days. But they took a gamble on it. Who knew that it would still be running on Broadway after more than 20 years, and now the subject of two hugely successful films. Part 2 is coming out in a few weeks. Enormously valuable. That's the most valuable property Universal Studios has ever owned. More than any of their movies before, and there's no end in sight. You get something like that, my God, you don't need anything else. That can finance your company forever. So, copyrights, yeah, and in conjunction with patents, ungodly amounts of money are at stake. Not often, but when it happens, people pay attention. Oh yeah. So questions thus far. There's a third major category of federal protection for intellectual property, and that is trademark. And one of you mentioned earlier, what about logos? You know, the Nike swoosh, the golden arches of McDonald's, you know, the way Ford looks on Ford automobiles, the way Coca-Cola is written in a certain script on cans of Coke, you know, all sorts of things. The Pillsbury Doughboy, you know, on all these Pillsbury pastry products. KFC, you know, the picture of Colonel Sanders there. Iconic images and words and designs. They have really one purpose, and that is to make the product or the service that they stand for instantly recognizable by anyone who's in the market. Again, in China and in India, where I'm also taught, you can see at a great distance, there's Colonel Sanders, his beaming white face there on a red background. Even if you can't read a word of Mandarin or Hindi, by God, he looks the same all over the world. And the same thing with the Doughboy and Nike and McDonald's, those golden arches, man, love them or hate them, you can find them anywhere. Surprisingly, KFC is way more popular in China than McDonald's. Far more KFCs than McDonald's in China. I think the reason is they took the basic KFC brand, if you will, and then they tailored it to local tastes. Yeah, they have, you know, a lot of the iconic American items on the menu. They also have like teriyaki chicken or Szechuan chicken, and it appeals to the Chinese market in a way that McDonald's hasn't really caught on with, not nearly to the same extent as KFC. But you want people to recognize your brand. You don't want there to be confusion between you and your line of restaurants or retail establishments or running shoes or whatever it might be. No confusion between yours and the other guys. We want ours to stand out so people will grab ours and never be confused and get the cheap competition. We want them to grab ours. So you want a logo, a design, a motto, a catchphrase, a look, a feel that people will instantly recognize. And I think it's pretty clear that this is more of an art than a science. You look at some of the trademarks that exist that have become iconic, like the Nike swoosh. Are you kidding me? Really? That's recognizable the world over for Nike. Not particularly creative. You know, my artistic abilities ceased to develop when I was about 7 years old. I still draw the same way now as I did then. I still know about 8 different colors, and that's it. I could probably come up with a Nike swoosh just doodling around, but I didn't. Somebody did, and it's their logo. McDonald's? I don't know if I would have come up with that stylized M from McDonald's. exactly Leonardo da Vinci in terms of its artistic brilliance, but people recognize it. Billions and billions served, yes, all over the world. People know the golden arches. Oh. And so, what's going to catch on is obviously the subject of huge amounts of research and marketing. And you never know for sure. You try, you come up with something and say, maybe this will be the new Pillsbury Doughboy. Doughboy's been king since about, what, 1960? That guy still, he gets poked in the stomach, he still giggles, and people love him. He's in all these ads, and you see him on a package of ready-to-bake chocolate chip cookies. I want the Doughboy. I don't want anybody else. Give me the Doughboy. And he looks the same in China and India and everywhere else in the world. So those trademarks are so important in making sure that you, as the trademark owner, retain the market share that you feel you have earned. You've got a certain amount of quality, customer loyalty, people love your stuff, they want yours, not the competitors. You want to capitalize on that. You want to monetize that by showing this is our stuff. When you see this symbol or that slogan, that's us. You don't see it, those are the crooks, those are the other guys. You don't want to mess with them. You want the real deal. Once in a while, companies like Coca-Cola come up with a new slogan. I remember a bunch of them, but it's the real thing, open happiness. It changes every few years, but they keep all of them. They are there as one of the slogans that people associate. Well, things go better with Coke. Open happiness. Who doesn't want to open up a can of happiness? Yeah. Oh, it's so satisfying. Open happiness. These things help people to find the products and the services and the goods that they want. And so, trademark law is big business. People like to come close to the line with trademarks. They want to come close to something that looks like the iconic slogan or brand or logo without actually being it. Again, in China, sort of all bets are off. But I went to a store in Beijing, the summers I taught there, and this store, and the sign outside was white and blue, much like a Walmart. There's a Walmart. I get closer, and even with my bad eyes, I said, oh, it's Woo-Mart, W-U-Mart. And other than that, it looks like Walmart, but it's Woo-Mart. I'm going in. And it looks sort of like a Walmart on the inside, but it isn't. They found a way, again, it's China, so that's a big dog, they get to get away with certain things, even though it's legally not proper. And they've cabbaged onto a share of what market would ordinarily go to Walmart. Now, there are Walmarts in China too, but there are also these knockoffs that are competing with them. The idea behind a trademark is it has to be unique, it has to be distinguishable, it has to be something that's not in common use. So you can't trademark a word like bread. You can't trademark cell phone. No. Those are just words that are generic in nature. But if you come up with some specialized use for something, like Apple, it was brilliant actually when Steve Jobs and his associates came up with the name Apple for their budding companies. No one's going to confuse this with the kind of apple that you eat or bake into a pie. But people realize, okay, this is something good, something basic, but it has so much potential. People are just going to want to be part of Apple. And so that worked. It'd be different if they were trying to sell apples. Sure. So they're using that as sort of a metaphor for their brand of electronics. Now sometimes trademarks, through maybe an excess of success, become so popular synonymous with the product, like Band-Aid. Band-Aid was originally a trademark for these adhesive bandages you can stick on your wound and easy to apply. But now people say, I want to buy some Band-Aids. And they don't necessarily mean the Band-Aid brand. They just mean anything like the store brand at Target or Walmart. I just want that. I'm going to go shop for Band-Aids. Same thing with a lot of, like Xerox. I'm going to Xerox me a copy of that. Even if I'm using some other brand of copier, some other brand of photo. I'm going to make a Xerox. It's become synonymous with making a photocopy. When that happens, you can actually lose your trademark protection. But it's sort of good news, bad news. You become so successful that you basically become the brand itself. Now, when you apply for a trademark, it's a little bit complicated on how long a trademark lasts. Initially, once granted, a trademark lasts for 10 years. But as Big Papi David Ortiz might say, not so fast, because it's not just automatic 10 years. You have 10 years if, at the 5th or 6th year, you file a statement of continued use. You have to file it with the Patent and Trademark Office saying, yeah, we're still using this. We're still using this logo. We're still using this catchphrase, this slogan. And you do that again at the 9-year point. Another certificate of continued use, just to show we're not letting it lie fallow. We're not throwing it away. We're no longer using it. No, we're still actively using it. We're still using the Doughboy. He's here in the state. We're going to file that certificate at the 5th or 6th year point and at the 9th year point. And then at the 10-year point, you can renew it. You have to file for renewal. Another amount of money. But then it's good for another 10 years. But you guessed it, you're going to have to file certificates of continued use. At either the 5th or 6th year, the 9th year, and then again renew. If you go through all these procedural hoops, a trademark in theory can last indefinitely. It can last forever. As long as we're still using it, like the Doughboy, who's still the emblem of Pillsbury, and probably will be for as long as I'm alive, maybe a lot longer, but they still file those certificates of continued use every so many years, and they always apply for renewal before the 10 years is up. Now you're re-up for another 10 years. Obviously, people are paid money to make sure that these requirements don't slip through the cracks. Oh, I forgot. As if you forget to file any of these with the Patent and Trademark Office, you lose that trademark, and it ain't coming back. You then lose it, and it's not in the public domain. So, a trademark has these peculiar reporting and filing requirements that are necessary, but if you file them, subject to renew, 1 10-year period at a time, indefinitely, potentially forever. Much like patents, it's the Patent and Trademark Office in D.C., just the trademark division. You can go online and search for recorded logos, slogans, etc. Just make sure whatever you're coming up with doesn't infringe on any of them. Because if it does, as with patents, infringement of a registered trademark is subject to a civil lawsuit in federal court where knowing violation can cause you not just to pay the owner of the trademark back for what they would have earned, but for what you did, but 3 times that, treble damages. So you disgorge everything you made from misuse of their trademark, and then 3 times that. Very expensive if you're infringing. So you want to make sure you hire people, keep them on the payroll just to make sure. We're looking through the database, and there's a lot to search through. AI can help, but you really want to double and triple check this to make sure you're not infringing on anyone's registered trademark. Almost done. Before we finish, I have to talk about trade secrets. significant way from the other types of intellectual property protection. Trade secrets is almost entirely governed by state, not federal law. There is no federal statute on trade secrets as such. State by state, each state will have its law on trade secrets. But no state requires you to actually submit the details of your secret. Trade secrets can be used for a lot of things. It can be used for recipes, for formulas, for certain procedures, certain methods of doing something. But one advantage of trade secret law is you don't have to give up your trade secret by filing a copy of it with any governmental agency. You talk about what it does, what its value is, what the purpose of this trade secret is. It makes the best chicken you ever tasted. Original recipe KFC. But they don't have to give the recipe. You just describe it. And to get protection and retain protection under any state's trade secret law, the main requirements are you safeguard that thing. You make sure that you have all sorts of procedures in place so very few people ever have access to the formula, the recipe, the process, the procedure, the algorithm. Very few people ever have access. You never divulge it publicly. In fact, you have multiple layers of protection, both physically, like in an office with all sorts of physical safeguards, and quadruple step authentication. No one's going to be able to hack into your computers and get access to it, etc. Because one sure way of losing trade secret protection is not treating it as a valuable secret. If you're loose about it, you get casual and sloppy in how you protect it, somebody gets it, you're not going to be able to bring a successful infringement case against them because you didn't care enough about your own trade secret to take adequate precautions to keep people from getting access to it. And that's why you hear all these stories about how few people ever have seen the formula for original recipe KFC or the formula for Coca-Cola, that kind of thing. People tend to rely on the trade secrets for these extremely valuable forms of IP because there's no danger, unlike with patent or copyright, there's no one in the government who has a copy of all this. And that at some point it could run out, and now it's in the public domain. Trade secrets, state by state, but pretty much universally, they can last forever as long as you're still protecting the trade secret as such. Any employee who comes into your organization, you make them sign a non-disclosure agreement. And it's bulletproof. It's written by the best legal counsel you can afford, saying you are not, under any circumstances, to disclose all or any part of this trade secret, this recipe, this formula, this process. And if you do, all these sanctions snap into place, and we will pursue you to the very limits of the law. Every employee has to sign these non-disclosure agreements. You have annual or semi-annual or quarterly briefings where everyone is reminded, God help you if you ever divulge any of this information to anyone outside this company. You make sure it's posted everywhere and no one makes a joke out of it. It's very, very serious business. If you do all that, your trade secrets should be golden in perpetuity under state law. The one area where federal law does enter in is the Defend Trade Secrets Act, which created a federal civil cause of action for people who choose to use the federal courts to bring what ordinarily would be a state lawsuit against somebody who infringed on their state-protected trade secret. Under the Defend Trade Secrets Act, people who prefer to litigate in federal court for whatever reason have a federal avenue to do that. But it's not because there's a federal statute underlying trade trade secret protection. Unlike copyright, patent, and trademark, there's no federal law that defines trade secrets and says, here's how you register them, and here's where our repository is. There's none of that. There's just the Defense Trade Secrets Act that provides an avenue into federal court. A lot of people prefer federal court because they think, well, the judges are better, they're more, I don't know, more professionally run, no particular reason other than, well, you have a direct avenue to the federal court of appeals if you don't like the result at the trial court level, and an easier route to the Supreme Court if it comes to that. But it's surprising how many of the most iconic, most valuable formulas, recipes, processes, procedures, methods in the world are not within the patent or the copyright world. For good reason. They're inventors, their creators decided to go with trade secret under state law. So they don't have to divulge to anybody what the particulars are of this. Now, it is possible under state trade secret law that maybe somebody who knows what they're doing could say, look, we have a team of very experienced chefs here, molecular gastronomists, experts. We can analyze this food and reverse engineer it. Or we can figure out how they do this. We'll buy a bunch of copies of it and take it apart one by one, figure out, well, how do they do this? How do they come up with it? And then we'll have our own path to that procedure, that formula, that recipe. If you can do that and it really is just reverse engineered, trade secret law can't protect against that. If anyone's free to buy a million buckets of original recipe KFC and analyze the heck out of it and see if they can approximate it. Just quirky personal example. Years ago, Outback Steakhouse had this walkabout soup. It was like a creamy cheese and onion soup. Not French onion, but cheese and onion soup that I just loved. A lot of people liked it, but they eventually took it off the menu. There are some people who have basically reverse engineered that and posted online a recipe for it that, by golly, is pretty close to the original thing. So I make it once in a while, and nobody's idea of Gordon Ramsay, but I can make a pretty good walkabout soup using that recipe. Now, Outback doesn't ever offer that themselves now, so they don't care about that trade secret, but back in the day they would have. So it's possible, maybe they can reverse engineer, but you take your chances. No one's really ever been able to knock off Colonel Sanders effectively. People can come close. But if they come close, he would still say, look, do you want the cheap imitation or do you want the good? Here's my logo. It's been the same for decades. It's known the world over. Come to the real thing. It's finger licking good, to use another trademark. Slogans like that, it's finger licking good, and there's a picture of Colonel Sanders. You've got to go to that even if the recipe is knocked off through reverse engineering. Now, interestingly, for patents, if you have a process patented, you're not allowed to reverse engineer it. They'd have to prove that you reverse engineered it, but if you can come up with the same invention through buying copies of the machine or device, that's it in question. That's still an infringement on federal patent law. So there's pros and cons with going patent versus trade secret to some extent. But Coca-Cola, KFC, a few other icons have gone with trade secret route because of the protection. You don't have to divulge the actual details of the recipe, the formula itself. So that's a very quick introduction to the law on intellectual property protection. If you're doing this for a living in another few years, if more. There's a very serious question about AI and copyright infringement, because these large language models have access to, you know, innumerable books, journal articles, TV shows, any form of information. They have access to all of that, and then they just sort of reprocess it and give it to you when you put in an AI search request. Well, what about all the copyrighted material that's been basically chewed up in that process? So far, the AI companies are not in any way paying any royalties to the copyright owners. They pretty much fed all of humankind's collected knowledge, all of our output, all of our novels and textbooks and nonfiction and fictional works into these huge databases. And whatever comes out, they just treat, well, that's what our AI says. And people who create that original content are saying, that's just plain infringement. That's a terrible violation of the copyright laws in most cases. It's the copyright that's being violated. We need satisfaction from that. And currently there's no avenue for them to bring a successful lawsuit. But as AI gets more and more prevalent, it's going to have to come to some sort of a resolution. I wouldn't be surprised, I'm not really good at prophesying things, but I hereby prophesy that during the next few years there's going to be some federal legislation trying to establish some avenue of copyright protection for people whose works are being used in the AI search engines. That you don't just become fair game, like all the work you put into your original research, your textbooks, your articles. It doesn't just become nothing, no protection, just because somebody feeds it into a database and digitizes it. Never had this before. I mean, this is on a scale beyond human imagination just a few years ago. But it's going to be a real cutting-edge issue, and it's something that you should probably devote some thought to. What would be a good way of dealing with this? How can you get a handle on all that intellectual property that's being chewed up and spat out again by these large language models, where people continue to produce original research, to do the path-breaking work that has gone into all of these publications before, if they no longer even get credit for it. They're not even subject to a citation. Like, credit goes to John Q. Public for his article on the, no, you don't get even a citation in ChatGPT or anything else, let alone a royalty. And so that plus the streaming world of music and videos have changed the former copyright laws immensely. It used to be recording artists would make huge amounts of money from selling, records, vinyl records, 45 RPMs, 33 1/3 RPM vinyl records, then cassettes, 8-tracks, CDs, and all of which have pretty much gone the way of the dinosaur, except maybe in retro form as collectibles. And that huge form of royalties that they used to have from selling their recordings has largely dried up and blown away. And so bands and recording artists, solo recording artists, except for a very few at the top, are scrambling to find other ways to make money. And a lot of it has to do with selling concert tickets at ungodly prices. They can still do that, and people will pay huge amounts of money to go see their favorite band or performer live, and that's how they're trying to compensate for the loss of all of those royalties they used to get from selling their records. And to some extent, that's also true in the world of TV shows and motion pictures. You used to have to buy those VHS or Betamax tapes, and then, you know, DVD and then Blu-ray, and they're still sold to some extent, but a lot of it's streaming services these days. And people will still go to the movies, but, you know, will they go as much as they used to? Will they wait till it's on streaming? It's sort of a moving target there to have enough revenue possible that people will still invest all the time and money and effort into creating these works that people want to see. Want to see the latest Batman or Superman or, you know, Fantastic Four or whatever it is. Well, that costs a lot of money to make those movies to the standard we're used to. And if, you know, you don't make enough of the box office and you're not selling DVDs or enough Blu-rays anymore, what are you going to do? It's sort of the original incentive idea that was baked into the Constitution. The Constitution recognizes in Article 1, Section 8, Congress has the power to protect these works, so people will have an incentive to make more of them. But technology itself has become sort of the enemy of the creative types with these other ways of accessing intellectual property. How do you balance the two? If you can figure that one out, you'll probably be a multimillionaire by the time you're 25. It's well worth thinking about because no one's really solved that issue yet. It's just sort of out there as the 800-pound gorilla in the room. We just sort of assume there's always going to be an endless supply of great music and movies and TV shows and, well, really, will there be? How do you know? And so much of it is available for free or near free, and there's not a stream of revenue anymore. Questions are common. When we come back Wednesday, remember, turn in your assignment number 1 before class, and then we'll start with contracts on Wednesday.
I have a question.
Yes.
Where do you turn in assignment number 1?
I'm sorry?
Where do you turn in assignment number 1?
You can email
Just
to
email
me.
it to you?
Yeah.
Gotcha. You have a nice day.
Yeah, you too. I'm sorry, I didn't realize.
No, you're fine. You can keep it off. I'm about to get out of here.
fuck? The fuck?